Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary CLE accredited webinar titled Mobile Privacy, an Overview of Legal and Legislative Developments. Before I introduce our speakers, I have a few announcements about today's event. For our phone participants only, if a problem arises during the program, please dial *0 for the operator. For continuing education purposes, those parties listening by phone only, please make sure that you have identified yourself with the operator. If your name has not been taken, please dial *0 now and an operator will take your information. Those audience members listening via computer do not need to identify themselves with an operator. In order to process your CLE credit, please download and complete the Mobile Privacy and Overview of Legal and Legislative Developments form you will find via the gray CLE widget in the bottom dock of your webcast console. Please promptly return those forms as instructed within them to the LexisNexis CLE team. We suggest downloading these materials shortly after the program begins. All New York attorneys will receive a more specific form following this event. Please consult your local rules for further guidance on CLE or contact LexisNexis at cle@lexisnexis.com. All attorneys joining us today will be given 2 4-digit codes randomly announced throughout today's call. Please be ready at all times to write these codes down so you may enter them on the appropriate CLE paperwork. These codes are required to receive your credits and verify your active participation in today's call. You must attend the entire event in order to receive these codes. Again, all CLE materials can be downloaded via the gray CLE widget in the bottom dock of your webcast console. The panelists today welcome your questions. You may submit your questions via the Q&A tab of the webinar platform throughout the program. The panelists will attempt to address as many audience questions that are submitted through the tab as possible during the last few minutes of the program. Please keep in mind that all questions may not be answered due to time constraints. We will not be taking questions over the phone lines. We will only be receiving questions through the web portion of the program via the Q&A tab. Now I'd like to introduce today's speakers. Complete biographies are included in the PowerPoint materials. Mary Ellen Callahan is Chair of Jenner & Block's Privacy and Information Governance Practice and has unique and broad experience with interfacing the protection of privacy, civil rights, and civil liberties with cybersecurity and national security issues. A nationally recognized privacy attorney with over a decade of outside counsel experience, Ms. Callahan served as Chief Privacy Officer of the U.S. Department of Homeland Security from 2009 until August of 2012. Ori Dinstein is the Chief Privacy Leader and Senior IT and IP Counsel at GE Capital, a division of the General Electric Company. He has global responsibility for data protection, and Mr. Dinstein works closely with the IT and information security teams as well as other functions to establish policies, procedures, processes, and tools related to data privacy and security and social media-related matters. Before we begin, I would like to take a moment and announce today's first CLE code. Please note, the first CLE code for today's webinar is 6741. Again, the first CLE code for today's webinar is 6741. Panelists, the floor is yours.
Thank you very much, Kathleen, and thank you all for joining Ori and I today. We're going to be discussing several issues associated with legal, legislative, and policy developments in mobile privacy, primarily talking about what's going on with regard to regulatory and policy updates with the Federal Trade Commission, California Attorney General, and other takeaways for what we can do with that. In addition, we always hear questions of what's going on in Europe, and Ori's going to talk about that. What to be worried about? What are the enforcement elements and activities? What to think about from a legislative perspective? And then I think importantly, we've got to think about how this impacts our own companies and infrastructure as we talk about bring your own devices and what that means for the landscape that Ori and I are going to address, and relatedly what that means for the risks and concerns that we have going forward. Ori's going to talk a little bit about what mobile security is, or what mobile growth is going on and the mobile frontier we're facing today.
Thank you, Mary Ellen, and welcome everyone. Delighted you could join us on this webinar on this exciting topic. And I think this slide almost doesn't really need much introduction. I think we all see in our daily lives the proliferation of mobile devices and the use of mobile devices and how they've become ubiquitous in our lives in so many ways that are hard to imagine, especially just a few years ago. The slide here talks about some of the growth. 70% of shoppers use mobile phones while in a store, probably mostly men consulting with their wives about the color of the tie, but I suspect there's a lot more of that going on. In terms of the mobile apps, 24% of Black Friday sales were done via mobile, 58% increase in malware, which is not surprising. The bad guys go where the data is, and as users increasingly use mobile devices, that's where the malware is going. 28% of mobile users and 48% of smartphone users have used mobile banking in the last 12 months. This actually, it says here Federal Reserve, and to those of you who have not seen it, the Federal Reserve Bank has issued a document in March of this year, which I have in front of me, and it's called Consumers and Mobile Financial Services 2013, and it has a separate set of statistics. It's just a survey. There's no sort of regulatory guidance there. But so some of their key findings, 87% of the adult population has a mobile phone, 52% of those phones are smartphones, 87% of smartphone users access the internet on their phone in the past week. 28% of mobile phone users have used mobile banking in the last 12 months, 48% of them, of smartphone users have used mobile banking in the past 12 months. So again, all of these statistics paint a very clear picture that, again, as we said at the beginning, mobile use is proliferating at a significant rate. And in fact, if you think about it, it's almost no longer logical to call these devices a mobile phone because the phone functionality seems to increasingly be the least used in this so-called mobile phone. And certainly any of you who has kids know that kids don't answer phones. They text you or they engage you on some chat service or Twitter or Facebook or Instagram, but answering the phone is not something that they do. And if you ask yourself, what have you done lately on your phone, you'll probably find that you've spent a significant amount of time on social media or email or various apps, whether it's map services or some of the many thousands of useful applications that you can download onto your phone. And again, the actual use of a phone is becoming somewhat obsolete. And this increased use of a phone as basically a mobile computer and a center of data, which increasingly is moving also into mobile payment services and other kind of uses, is really what's driving a tremendous amount of interest in these devices at all levels. And as we'll talk about throughout this webinar, there's a lot of regulatory interest. There's, of course, litigation. There's regulation. And we'll also talk at the end about the BYOD phenomena, or the proliferation of personal phones in the workplace. So, Mary Ellen, let me turn it to you.
Thanks, Ori. And as Ori talked about, the Federal Reserve is released this report that they had. But in addition, there's a variety of other actors who have been releasing reports that are related to mobile use for exactly the reasons that Ori said, the proliferation of it, the use of it, the technology, the strength of it. And I'm going to highlight a couple of things that are going on kind of domestically and what the current posture is of some of the enforcement agencies that have been talking about mobile privacy in particular. And I think we're going to use the word kind of mobile privacy generally, but it's a subset of privacy enforcement. With that said, there's been an absolute explosion of focus of policy issues associated with mobile devices. First, let's talk about the Federal Trade Commission, which, of course, enforces unfair or deceptive trade practices based on its Section 5 authority, and that's how it derives its kind of privacy enforcement for consumer protection issues. And the concept there is essentially that companies should not engage in unfair, which are that customers couldn't avoid it, or a deceptive. There's a misstatement or an omission in the scenario, and their enforcement associates basically with this unfair or deceptive trade practices. The FTC has been prolific in releasing reports on mobile issues, and I have several of them listed on this slide. And I want to just highlight what is going on with these reports, the recommendations, and what to think about as you work through. I've listed the two first reports on mobile apps. The FTC was actually the first to do reports on mobile apps, and specifically on mobile apps for kids. And the FTC has highlighted apps for kids for two reasons. One, the FTC has statutory authority under the Children's Online Privacy Protection Act, and the FTC was in the process of updating that regulation that they have, and therefore they did these two research reports on mobile apps. And basically, as you can see by the headlines, or with all these puns, disclosures still not making the grade, and the disclosures are disappointing. And that kind of set up the framework for them to be able to say, listen, we need to be clear that the COPPA regulation applies to mobile, because, again, that's where everything is going, as Ori said, but also that the standards are clearly defined. So those two reports, as I said, were the seminal reports on what's going on with mobile apps, and particularly with kids. The focus on these issues were on deception and on omission, not saying what's going on, but also in terms of notification to parents, which is a unique issue for kids. So after these two reports came out, the FTC released its COPPA rule. It involves mobile a lot. We're not going to be talking about that beyond a couple of references in here, but I wanted to explain the context of those two reports. With that said, the FTC then had a couple of other reports that I'll talk briefly about. One is these FTC recommendations, the mobile privacy disclosures, building trust through transparency. FTC released this a couple of months ago in February, and they were recommendations on what to do for mobile scenarios and for people who particularly have applications. And the concept here, again, is to not be deceptive, to explain what's going on, and to not have an unfair practice that consumers can't get out of. So briefly, the FTC recommendations are to allow easy access to privacy policies for applications. So that doesn't necessarily mean before download, and I'll talk about what California's recommendation is. FTC also wants to provide just-in-time notices and consent, particularly when there is an unexpected transaction. So all of us who have who use the map applications that Ori was talking about, that you'll get a notice that says the map application wants to use your location. In that scenario, you can say okay, and so on. It may be unusual if I was using a flashlight app for them to want my location. The FTC would argue that you'd want just-in-time notices for that. The FTC also is doing a trend that we've seen throughout this whole process, which is that geolocation and unique identifiers are treated as sensitive information. And we'll talk more about that. As I said, the other guidance that the FTC wanted is make sure that the consumer disclosures are accurate, consents are clear, and that if you have third parties on your site, that you may want to, you do want to coordinate with them and make sure that we know what's going on with them and that those are clearly disclosed. So the FTC's recommendations, as I said, a couple of months ago, trying to be a cornerstone element of that. The FTC then did two more documents that I think are worthwhile taking a look at if you have time. One is called the .com disclosures, or how to make effective disclosures in digital advertising. For those of you who have been in privacy a long time, the FTC's .com disclosures are a kind of a seminal piece that the FTC did in 2000. So we're talking a long time ago from a mobile frontier perspective. And they hadn't been updated, but they were just updated in March, where they had examples, a lot of examples of how to make clear and conspicuous disclosures, particularly about representations about a product, representations about free services, whether or not there are significant provisions or restrictions associated with elements, and how to do that in the very small space that mobile technology has, where they You can't it's hard to make a full and fulsome disclosure or clear and conspicuous disclosure. So the FTC has given a lot of physical fines and disclosures to that, and it may be worthwhile, particularly if you're doing advertising in a mobile area. And then the final report that the FTC had was on mobile payments, and Ori talked a little bit about that and the proliferation of mobile payments and how we may be moving to these no longer even being phones but being payment devices. So this paper, plastic, or mobile report that the FTC had has some recommendations in it, but it's primarily a summary of a workshop that they did last year with that same title. And the things that they are concerned about from a mobile payments perspective and things to think about from a mobile payments perspective are essentially the elements of how can a consumer complain to you, or how is there a consumer redress customer service mechanism available. And in addition, one of the major concerns for all of the payment element was the concept of cramming and having unexplained or inexplicable or unauthorized payments that appear on a mobile bill. And those are the issues there. There are, of course, going to be multiple platforms for mobile payments as we move into this scenario. And I think it's worthwhile watching that, because I think mobile payments is really going to be a growth area as we talk about, banking. We talk about credit card information, using the phone as a payment structure itself, and other online payment structures such as the PayPals of the world wanting to get into these scenarios. So that's kind of what's going on with the Federal Trade Commission. They have the civil law enforcement authority under their unfair deceptive trade practices activities. Two things on the California Attorney General, which is, as I said, the California Attorney General, Kamala Harris, has been very active in this area. She's done three things that are worthwhile to note. One is she signed a joint statement of principles with platform providers last year in February. Immediately after, interestingly, the Mobile Apps for Kids report that I mentioned from the Federal Trade Commission. So there's a little bit of a competition going on here in terms of who can get involved. But this joint statement of principles with platform providers is a very interesting one, that she reached out to all of the platform providers for mobile devices. So Apple, Google Play for Android devices, BlackBerry, Microsoft, the other kind of operating systems for mobile devices, and had a statement of principles with them. Facebook, by the way, joined in June, so she went with the first six, and then Facebook as a platform, to make sure that when you're looking at applications, that you're able to access the privacy policy before you can download, that it's clear what's going on. These just-in-time notices I mentioned, that's really a platform provider scenario. So she had these broad statements with the infrastructure of mobile devices, as I like to think about them. And that kind of set the stage, and it also helped mobile devices with their own disclosures, because if the platform providers allowed it, then the devices, then the application developers could also provide privacy policies and so on. She followed up in the fall with writing letters to several of the top 100 app developers, claiming that they weren't in compliance with the California Online Privacy Protection Act, or CalAPA. And briefly, CalAPA, which I'll talk about a little bit later, is a state law from 2003 that applies to any online service that is provided to or displayed to California residents. Ergo, it has essentially a national coverage. The CalAPA says that if you're providing an online service, you have to have a privacy policy that is clear and conspicuous and easy to access. And so the California Attorney General has taken the position that CalAPA applies to mobile devices and specifically to mobile applications. She wrote to 100 developers and basically it was a Halloween treat that she provided to them. And then she followed up with some litigation that I'll talk about in a few minutes. She, like the FTC, released these recommendations, and in fact, the California Attorney General released them a little bit before the Federal Trade Commission's recommendations for mobile privacy. They're very similar in the sense of disclosures, making sure that people can access things, providing access to the privacy policy before the download is expressed and heard. because of this joint principles or statements that she has. She wants just-in-time notices and limit collection and retention of sensitive data for only those things that are necessary for the core functionality. One of the things that's relatively controversial about her recommendations, which of course none of these recommendations are binding, they're only kind of guidelines for app developers and for platforms, is that she'd like the application developers or applications to encrypt personal data, including device ID, email address, or telephone number in transit and in storage. So that means anytime that you're sending the device ID, which is how you can download applications and so on, she'd like that to be encrypted because she considers that to be personal sensitive information. That is not required, as I said, by law, but that is one of the recommendations from the California Attorney General, which is not expressly in the FTC's recommendations. So that kind of sets the stage in terms of who's talking about mobile and what they're talking about. I wanted to mention and spend just 1 minute on the National Telecommunications and Information Administration multi-stakeholder process on mobile transparency, which is a mouthful. I understand that, but I just want to briefly describe what NTIA is doing and their multi-stakeholder process. Right now, again, we're talking about these recommendations. The NTIA is a subset of the Department of Commerce. You all may recall last year in February as well, the Department of Commerce and the Obama administration announced a Consumer Bill of Rights. The NTIA has been assigned by the Obama administration to start to engage in a series of multi-stakeholder processes to try to find the best solution for different privacy concerns. The first one that they're dealing with is actually on mobile transparency. They started last summer, and they're working on their own set of recommendations that are narrower than the FTC or California Attorney General's recommendations in that they're just about transparency, disclosing what is happening. They're not about encryption. They're not about just-in-time notices, but they're about disclosing what's going on with the mobile device and how to do that. That's a wide engagement from companies as well as from a lot of privacy advocates, associations, and so on. If the NTIA gets the final document, it'll probably be finalized in June, I would expect. And what would happen there is a company would expressly or affirmatively say, I am complying with the NTIA guidelines. And if they don't do that, then the FTC or any of the attorneys general could go after them and say, you lied to us, you engaged in a deceptive practice by saying that you agreed to these standards and yet you haven't implemented them. So that would be kind of the enforcement mechanism there. So that's what's going on in terms of domestic and regulatory actors. I'll turn it over to Ori for the kind of, what does this mean for you as companies and as individuals?
Thank you, Mary Ellen. That was great. Look, the reality is that the world we live in today and the world that the regulators have been looking at is one where you access an app store, you download an app, which you download for certain functionality that you're interested in. You don't really understand what's happening in terms of your personal data, what data they're gathering, what they're not gathering. Probably you're surprised to learn that they've accessed your contacts or your calendar or your photos or your audio, and they know your location. And I'm more familiar with the iPhone than with the Android, and they've certainly become a lot easier to, the operating system has changed to make it easier to see who's accessing what and how to better control things. But it's still something that's a little bit complicated, and the reality is that there's a lot more that's happening that's not controlled at your device level, and that's what the regulators have been looking at and what they've really been targeting. Now, they'd like us to move to a world which is vastly different, one in which before you click to download an app, you'll get a message telling you what personal data is going to get gathered and who else is going to see it and all the players in the ecosystem, how they're going to participate and what exactly is going to happen. And all this is going to happen in a very small number of words or icons because you can't really take up a lot of real estate on the phone. And all of this is going to happen just in time but without overwhelming you, which means that if something's only going to happen down the road when you decide to activate a feature of the app, then you don't want to learn about it now, but when you turn on that feature of the app, then it'll remind you that now you're going to share your location. And it's clearly from a consumer privacy perspective, it's the right direction. And again, I think that part of this stems from the fact that the world we're living in now has been so much of a Wild West, and it's really bothered the regulators to the point of setting much clearer guidance. It's going to be fairly difficult for companies to really meet all of these requirements, and again, especially challenging are some of these that require detailed descriptions of everything that's happening, and yet at the same time be brief and concise and to the point, and don't give me a 20-page disclosure because nobody's going to read it. So that's where I think there's going to have to be a lot of judgment calls. One thing that's interesting amongst the various reports that Mary Ellen mentioned, they each have a set of recommendations, but they each target different groups with a few exceptions that appear in all of the reports. But just to let you know, and I don't have a chart of all of these categories by report, but certainly all of the reports addressed recommendations to app developers and to app stores. But then the following additional categories appear in some reports but not others. Device manufacturers are targeted in some of these documents. Platforms, operating system, ad networks, mobile carriers, and application trade associations. So we've got all these different players who are part of the mobile ecosystem that, again, the various reports have targeted certain of their guidance. Some of these appear also in the form of mandatory actions. Some of them appear in the form of more optional actions or recommendations. So it really depends. And, sometimes when the FTC speaks, even if they don't say that it's mandatory, you certainly need to keep an eye out for what the FTC is doing, and we'll talk about that in a little bit. So things that may seem discretionary, once they start appearing in enforcement actions, become a little bit less discretionary. But as a real general matter, I think that the key point, and probably the most important point, is the point about transparency, is really to understand what is happening, to avoid the situation, for instance, that Google Street View found itself that they were collecting data which they claimed they were doing inadvertently. You don't want to say, I'm inadvertently collecting all of your contacts, or inadvertently copying all your photos from your phone to my server. If you're doing it, there's got to be a reason, and it's got to be disclosed. And again, you have to know not just what you're doing, but where you are in the ecosystem, what data you're gathering if you're an app developer, what's going to the App Store, what's going to the ad networks, which networks are advertising in conjunction with your app, what's being sent to the device manufacturer, and so on. All of this is something that you need to understand and you need to disclose. And this ties to the last bullet on that page, which is privacy by design, which really is, once you understand all of the elements, to ask yourself, is this what I intended, or are there things here that are unreasonable and that I really need to do something about? Because again, some of these apps, you understand why they need your location, but I have to tell you, I recently looked at one of my iPhone alarms, and when I saw that that wanted my location, I could see why they might need my location so they can adjust the time to know when I'm in Europe or when I'm in Asia. But for them to constantly know my location for that, a few times a year that I'm traveling out of the country and they need to know to change the time, I figure I'll do it manually. And that's one of those things that you really want to know and not have to stumble upon inadvertently. Or again, apps that have been using, the audio on your phone. Geolocation is a really sensitive point because that leads to ubiquitous tracking. And that's one thing that, I always tell folks when I talk to them, if there's one entity in the world that always knows where you are, it's your mobile carrier. They constantly know where you are, which is sometimes helpful if you're lost somewhere and they can help locate you and send help your way. But sometimes you really don't want people to know where you are. And of course, you can always turn off your phone, which I think people forget is an option. And it's always a good option if you don't want to be found. But when you look at location data and you think about it, you can start to appreciate the amount of knowledge that you can accumulate from location data. Just for example, if you're the phone carrier and you see the location of my phone every morning at, say, 7:30 in the morning, and then you see the phone moving along at the same road every morning, and at 8 o'clock it stops at that place, and it sits in that place until 5, You don't need to be a rocket scientist to know that this is my house and that's where I work. So you've now accumulated data just based on location. You can know where I like to shop. You can know how often I go out at night. You can know where I go out. All of this data is being accumulated. And in today's world, especially in the U.S., we are at the mercy of the carriers in terms of what they do with that information. Do they aggregate it and sell it to somebody else? Do they share it with somebody else for free? Do they not do anything about it? Do they use it to advertise? And that's really the point why geolocation is so sensitive, because, again, it's not just the phone carrier who knows where you are, but, again, any app, Google Maps, for example, any app that you enable location and say you're allowed to know where I am, that becomes the same thing. So that app from two developers in a garage, my alarm app, if I had not turned off the location, they now know where I am constantly. What are they doing with that data? Who are they sharing it with? Maybe I trust my mobile carrier, but do I know who these guys are behind that alarm app, and do I really want them to know where I am 24/7? So these are the things that we really need to think about and be very sensitive to, and that's part of what the regulators talk about when they talk about sensitive information. And obviously, to the extent that this is a payment app, if you're gathering credit card numbers, bank account numbers, anything, of course, that might involve Social Security numbers, those become a lot more crucial data elements that you need to think long and hard. Why am I asking for that data, and how am I keeping it, and what am I going to do with that data? And again, the other points I think we've really touched on the just-in-time concept and having a privacy policy that on the one hand gives me all the right information, but on the other hand is not so overwhelming that I'm not going to be able to digest it. And just as a reminder, the FTC took enforcement action against Sears in connection with certain data gathering, which they had disclosed in one of their privacy policies, but it was disclosed, I forget exactly how far down the policy. I think it was something on page 16 out of a 26-page privacy policy or something like that. But the FTC took the view that that was unreasonable disclosure. No one reads privacy policies, and the few who wade into them are not going to read all the way down to the bottom. So if something is important, put it at the front, put it at the top, make sure that people see it clearly, because that's what they care about, what data they're sharing and what you're doing with the data. So again, I think it's overwhelming to read all of these reports and to really start to figure out how to live up to all these expectations. But at the end, I think if you figure out that they can all be distilled down to 3 or 4 really basic rules of just being fair and being transparent, then I think you'll find life a lot easier. And with that, I'll turn it back to you, Mary Ellen.
Thanks, Ori. We actually, I think we're going back to you because we're going to talk briefly about the Article 29 Working Party recommendations, which have some more detailed requirements than even what the FTC and the California Attorney General has been working on. Sorry. Ori, did you want to talk about Article 29, or did you want to just have me talk about enforcement?
That's fine. I'll talk about the Article 29. I thought we were doing the FTC first. So sorry about that. So the Article 29 Working Party, again, a lot of the same of what we had discussed. Their report is more granular, and as you can expect, the Europeans, because they have the European Privacy Directive, which is a different and far more comprehensive privacy regime than we see in the United States. They in their report, they have a very detailed analysis of how the mobile ecosystem fits into a world of privacy. Things like consent, informed consent, notice, choice, security. So they really take the time to wade through a lot of the different elements of the European privacy regime. And the reason I say privacy regime, because to those who are unfamiliar with the European structure, the European directive, being a directive, has to be implemented by member states into their local law, which means that we have 27 privacy laws in Europe today. By the way, as a footnote, the Europeans are in the process of looking to introduce a new regime, a new privacy regime in the form of a regulation. So there is a proposed privacy regulation, and regulation, unlike directive, is self-acting, meaning it does not need to get implemented into local law. And there's a lot of significant changes in the regulation compared to the directive, and there's a lot of controversy, but that's a whole different webinar, and so I won't wade into that. But the only point I want listeners to be clear on is that when we talk about the European directive, the directive is just a framework which needs to be implemented, so we have 27 different privacy laws. But there's an advisory body in Europe which constitutes of a representative of each of the data protection authorities in Europe, as well as the European Data Protection Supervisor and representatives of the European Commission, and all of that forms a group called the Article 29 Working Party, and they issue advisory opinions which don't have the weight of law. I'm not sure I would even give them the same weight as an FTC report, but they are very influential in terms of what's in them. And again, while they don't form the basis for enforcement actions, they do form the basis of education guidance, and a lot of DPAs find these reports very influential, and you may find yourself in a local enforcement action based on local law, which has been perhaps triggered by the guidance or thinking coming out of an Article 29 Working Party recommendation. So again, they have a long list of recommendations for some of the same actors that we've seen in the U.S. and some different actors from what we've seen, and a lot of the same things: transparency, notice, only collect information that's truly necessary. They focus a lot on data deletion. One of the pillars of European privacy law is that data should only be collected for specific purposes, or another way of calling it is purpose limitation. So if again, using my now, this is now my permanent example on this webinar with the alarm clock. So if the purpose of the data that I had given them is to wake me up in the morning, then that's the only purpose for which they should be using that data, and they should not be selling that data to anyone else. They should not be using it to advertise other products or services to me. I've only given them permission to use my data for a very specific purpose. And hand in glove with purpose limitation is the concept of data deletion, which is you should delete data when it's no longer necessary for the purpose for which it was collected. So if you go into a store and you buy something at the store, and as part of giving the store your credit card number in order to execute that transaction, and they might need additional information from you, they might ask you for a driver's license to prove your identity at the point of sale. Whatever information they have, once they've concluded that transaction and received the payment from the credit card company, arguably they no longer need that information. They certainly no longer need any information about your driver's license, and you would argue that that data would now need to be deleted, and they can't keep it just because they took it. So the Europeans are very strict on these concepts of purpose limitation, data minimization, and deleting data that's no longer necessary for the purpose for which it was collected. And these concepts appear in a very clear way in the Article 29 recommendation. And they certainly mention and reference the FTC reports and the California AG report. Their report came after, and they note those reports, and there certainly is. I wouldn't say that there's a lot of cooperation in the mobile space between the regulators in Europe and in the United States, but they're certainly aware of what each other is doing, and there's a bit more cross-referencing to the thinking on both sides of the ocean, and I think that's a good development. So again, I don't think that there's anything radically different in the European recommendations that will change what I've said earlier in terms of the high-level recommendations and best practices that if you follow those, you should be okay. But again, perhaps the one key difference is as I said, data deletion, which I don't believe was a clear topic of discussion in any of the U.S. reports. And the other thing, which is very important to highlight, is the concept of informed consent. Because again, the Europeans take the view that you can't consent to something unless you understand it in full. And so again, if somebody comes to you and says, I need your name and your email and your phone number, your mobile phone number, and they don't really explain to you all the ways that they're going to use the data and how long they're going to keep the data and what about the security. And if you say, sure, you can have my data, most of us would say, well, you agreed, so that's fine. But the Europeans would say, no, that was not valid consent because it was not informed consent because you didn't have enough information in order to form the basis of a viable consent. So that's something else to watch out for in Europe, that the level of information that needs to be disclosed before you can assume that you have received a consent is the bar is much higher than it is in the U.S.
Thanks, Ori. And I think that really helps set the stage for, okay, so what's the concern here? What happens if I don't abide by these recommendations? Ori made the point that, the FTC has made these recommendations, and they may be aspirational, but what they do is they define a playing field that if you comply with these standards, you are likely not going to have an enforcement action against you. You are likely not going to be considered to be unfair or deceptive. So the converse of that is also true, that if you don't do all of these things that they recommend, that there is a possibility, albeit perhaps small, depending on which one it is that you are doing or not doing, and Ori talked about kind of the issues with that and how to comply with all this myriad of requirements. But at the same time, if you're outside that scope, you fall into that potential unfair or deceptive trade practice scenario. And I want to talk about two consent orders that are worthwhile thinking about and knowing about with regard to mobile privacy in particular. Briefly on consent orders, if you don't know, the FTC, as I said, has civil law enforcement authority that is primarily available under its Section 5 Unfair or Deceptive Trade Practices Authority. The FTC very rarely litigates that standard. What they do is they say, hey, they say, hey, company that we're investigating, we could negotiate a consent decree and you could agree to this and you can neither confirm nor deny that you had violated the law, so you don't have any litigation risk or lower litigation risk. But you have to agree to a 20-year review and a privacy policy review and reports, and there's definitely a reputational cost associated with that. Why do people agree to that? Well, because the flip side, because this is an administrative law process, if you're litigating it, the first place that you go under this is often to an administrative law judge who is paid for by the Federal Trade Commission. And if you then appeal that decision by the ALJ, you appeal to the Federal Trade Commission. And so depending on which litigation posture the FTC is in, it could be until the third stage where you would get what one would consider a neutral actor. The ALJs consider themselves to be neutral, but, if the FTC is signing your paycheck, that may be more persuasive than the company is, could provide. Therefore, a lot of people do these consent orders, and there are two consent orders that have been disclosed in the mobile space that are worthwhile mentioning. One is against the mobile device manufacturer HTC, or HTC America expressly, which is the first consent decree against a mobile device manufacturer. And it's important for a couple of reasons. One, as noted on point number one, the definition of covered information is very broad, and it includes all the information, such as precise geolocation that Ori talked about, static IP address, MAC address, which is the individual address for your mobile device, how you're able to get to it, and also cookies and anything else that's basically associated with a particular device. This is part of a trend that the FTC has been doing. In addition, they did it with the Children's Online Privacy Protection Act rule, which is there's a concept of personally identifiable information, which is usually name, actual address, email address, telephone number that's individually associated with an individual. What the FTC has been doing is broadening that, and as Ori said, your mobile device is with you usually 24/7. There's actually a statistic that says 80% of people sleep with their mobile device closer to them than their spouse, which is really telling for the state of both marriages and mobile devices. But with that said, you have the device there, it's available, it's accessed, and so even if it is just a device ID or a MAC address or something, that could be individually associated and persistently associated with you as an individual. Therefore, the FTC has been increasing the definition of either covered information, individually identifiable information. This HTC consent order has the broadest definition yet. The FTC had two theories against HTC. One was an unfairness claim, which is relatively unusual, but is often in the scenario where a consumer can't avoid it because there's something physically wrong with the system that the company has provided. In HTC's cases, it was a security gap, and it was a data breach opportunity where hackers could come through and exploit a security gap in the HTC software where you could have hackers pull down information from the mobile device. And this gap was exposed and known for quite some time, and HTC didn't patch it. In fact, it was discussed in blogs and so on with black hat hackers. And so the FTC took the position that HTC was unfair in its practice. In addition, the FTC had two deceptive claims against it, which were that it had disclosures in its manuals associated with the device that were not accurate in terms of how it described the security system and what it could do in terms of the patching. So the FTC went after HTC both for an unfair security practice and two deception claims. And that's worthwhile to note that the claims were not in a privacy policy, which is a typical way of presenting scenarios, but instead were in manuals that were associated with the device. So you should think about any time you make a statement, whether or not it's an accurate statement of the practices of the product or of your company. The second FTC consent order that I just wanted to talk about briefly was with the social network PATH. And the PATH social network consent order was announced the same day as those FTC guidance, the recommendations, I talked about. So a few months ago, it was a social network, and it had two claims. One is that it had actual knowledge of collecting personal information about kids from under 13, so that violated COPPA. So they were fined $800,000. But in addition, they had a practice that Ori talked about, which was to collect your entire mobile address book, your IP address, and device ID, and pull a bunch of information down that was not relevant, was not necessary, and candidly was not disclosed. And therefore, that was a deceptive practice. So PATH engaged in a deceptive practice as well as violating COPPA. With regard to some enforcement actions on the California side, I mentioned that the California Attorney General had sent out this little Halloween treat to the top 100 app developers about the need to display a privacy policy before the application was downloaded. The California Attorney General has taken the position that the CalAPA applies to all mobile devices and to applications specifically. Therefore, she sent this letter out. Based off of the statute itself, it's not clear that that's the case, but the California AG decided to sue Delta Airlines for violation of CalAPA. What's interesting about selecting this case is that Delta has a fairly unique defense, which is the Airline Deregulation Act has an issue about federal preemption associated with airline activities. And therefore, Delta, it appears, based off of the pleadings, is pursuing this in litigation, and they're currently, as I said, in the pleading stage in California. Therefore, it will be interesting to see if the Airline Deregulation Act trumps or whether or not there will be an actual court case who says CalAPA does apply to mobile applications. And whenever they do decide that, it will be indeed an issue of first impression. So that's worthwhile noting, and it's interesting, again, that they selected Delta because Delta had this relatively unique defense. And so, in general, in terms of litigation risks, because we're talking about enforcement and litigation right now, it certainly is a growing privacy risk for mobile companies. As I said, there were 6 class actions that were filed in December alone related to privacy violations, and some of them were associated with COPPA, some of them were analogous to COPPA. But there also are several states that have unfair or deceptive trade practices with private rights of action in those states that can relate to those misstatements or omissions in terms of information sharing and in terms of unfair data security. And I list a few of them there. In addition, as I said, the more recommendations that get laid out, the more that there is a framework in which people are supposed to be disclosing, the more likely an unfair or deceptive trade practice type of litigation could come up in a private context based off of these, 17200 in California is quite well known. And so that can be a exposure for companies as well. And generally having those, for example, the NTIA paradigm out there, if companies agree to it, that's an express statement that they're agreeing to it. And then there's also the TCPA, the Telephone Consumer Protection Act, which prohibits making calls for using an automatic telephone dialing system or artificial pre-recorded voices. What's relevant about that for our purposes is a call includes text messages. The TCPA has pretty much a strict liability standard, and it also has the requirement that you must have consent before sending text messages, and the text message fines are extraordinary for each entity. And so there are some very big TCPA cases that are going out that are essentially related to text messaging, to advertisements, to promotions where people may or may not have known that they were signing up for these types of scenarios. So it's worthwhile to keep all of those issues in mind as you engage in mobile practices, and particularly in terms of mobile disclosure. The next slide is actually also me, so we're going to finish up with some of the points I want to talk about, which is legislation. As you know, some of these issues, as we discuss, are only related to this kind of unfair or deceptive trade practice authority. With that said, the possibility of legislation certainly exists. But let me talk a little bit about what's going on with each of the U.S. Congress, and then California as kind of the exemplar of the state issues or concerns. The U.S. Congress hasn't taken any action on mobile privacy because it may not have taken any action on a lot of things. With that said, there have been several bills that have been introduced, and I've listed a couple of the different types of bills. The Franken location privacy bill and the Markey Chaffetz privacy bill that I mentioned, 2012. Both of those were introduced almost immediately after the U.S. versus Jones case was passed, where the Supreme Court determined that putting a GPS location device on a car was indeed a Fourth Amendment act, and so it needed a search warrant in order to not be an unreasonable search or seizure. Now that's associated with obviously law enforcement and government, but these two bills were introduced because the logical extension to Ori's point about the discussions is that you would want to have a disclosure about what's going on with your mobile device, because that's not physically attaching a file to you. That's just you walking around with your device. They have not been reintroduced, but I anticipate that they will. Senator Franken and Representative Chaffetz have been continuing to talk about mobile device and geolocation privacy a lot in policy areas, and so I anticipate that will be continued. Representative Hank Johnson has floated this Application Privacy Protection and Security, or APPS Act, because we love acronyms in Washington. But the APPS Act has floated a discussion draft, which, among other things, takes a lot of the elements of the recommendations of the California Attorney General, because it was the only one out at the time, and also says that the NTIA standard, if you agree to that, again, it's not done yet, but if you agree to the NTIA multi-stakeholder process, then that would be a safe harbor. He, too, has not introduced that yet, but it's certainly part of discussions, and I would anticipate that something would be introduced either by Chaffetz or by Johnson sometime before the summer. With that said, who knows how successful they'll be in terms of passing legislation in the Congress. It certainly has not been widespread activity, but it's worthwhile noting what also happens, evidenced by the Supreme Court case, is when things happen, when there's a big catastrophe, when there's a big change in the court or something, that may prompt a response or an action by Congress. And that leads me to California, because one of the things that may happen is if California passes, if California passes any of these types of legislative proposals, I think that the U.S. Congress may be pushed into action by some of the trade groups who may find some of these proposals too onerous. So let me briefly talk about the California legislative proposals, and then I'll end with a note about what's going on in the other states. This 100-word privacy policy legislative proposal is one exactly that, is you have to have a privacy policy that's only 100 words. That kind of goes to this concept of a layered privacy policy or an iconic privacy policy where you use icons to indicate things, even if you have the long narrative and the long disclosure that has all the catchphrases. Ori was talking about the Sears case where you bubble up or put the highest level of the issues at the high level. I've also talked about a nutrition label approach to privacy policies. All of that has been kind of batted around and is a theme through these recommendations, and NTIA may actually come up with a standard set group of things to disclose. But this 100-word privacy policy wouldn't be the top level. It would be the full privacy policy. It's not clear that one's going to pass. The Right to Know Act is the Shine a Light. They have great names in California. Shine a Light is a law that says that you have to notify, if a consumer writes to you, you have to notify them with whom you have shared marketing information over the past 12 months, including affiliates that may include subsidiaries within your same company, and you've shared this information for marketing purposes. The Right to Know was supposed to amend that to include device ID, cookies, IP address, and again, with whom you're sharing it for marketing purposes. That has just been tabled as of Monday, and so we weren't able to update the slide. But I also want to note this California Medical Information Act proposal, and you see the language there, which talks about any application software that is designed to maintain medical information to manage or diagnose a treatment of a medical condition. Well, is that your weight loss app? Is that your Fitbit? What is that, and what does that mean in terms of suddenly making everybody fall within the California Medical Information Act proposal? One other legislative proposal is about marketing to kids and allowing kids to have that right to delete information that Ori talked about. So that would be kind of the first time the U.S. would have that concept of deletion as opposed to just correction in privacy policies. And so that one is also worthwhile watching, even though it's not expressly towards mobile, it's more broadly towards online entities. So with regard to California, California is always tricky for legislative purposes, and but it's worthwhile to keep an eye on that. I think that marketing to minors is the most likely of the legislative proposals I have to act. With regard to what's going on in 49 other states, California very much has been a bellwether on privacy issues. And it's also very much a feel-good story in California, even though they have all the technology there. With regard to mobile privacy, the other legislators have not been as active. With that said, they certainly may follow California's lead and have this mimicking effect, as happened with data breach notification laws. I also would just do a one postscript on state activity, which is that the state attorneys general have become very interested in privacy issues generally and mobile privacy specifically. The head of the National Association of Attorneys General, a guy named Doug Gansler from Maryland, and he has launched a privacy initiative among the National Associations of Attorneys General. he and the Connecticut AG wrote to Living Social about a breach that they had and what happened and asked for a lot of detailed information. So I would anticipate from an enforcement perspective that these would that the attorneys general, in addition to California, are going to get more active in enforcement scenarios. With that, I will turn it back to you, Ori.
Thank you, and I think that brings us to bring your own device, or BYOD. And we only have one slide on BYOD, but I'm actually going to cover quite a bit of ground here. So hopefully those of you who care about this issue will, this is the time to take out your pen and find a piece of paper, because there's much more than meets the eye on the slide. And let me start with sort of what's behind BYOD, because I find it to be a fascinating development and one that has caught many companies off guard. And as I often tell people when we talk about this, I don't know of any company that has sat and that their senior leadership sat down and had a strategic decision about BYOD and decided that BYOD is the right thing to do. First of all, in terms of the what, BYOD really has to do with employees bringing their personal device to the workplace and connecting it to the company infrastructure. So in effect, that allows them to eliminate the need for a corporate device, and they can access their email and corporate applications and various things depending on the details of the BYOD program. They can do it all from one device. Very often, these are iPhone devices and Android devices, as opposed to the ubiquitous BlackBerry that tends to proliferate in corporate America, although it will be interesting to see how long that continues given the significant challenges that BlackBerry has faced, although they have come out with a new phone that looks very promising, so they may turn the tide, but some folks think that may be too late at this point. But regardless, the point is people have and it's not just phones, it's tablets. So a lot of, again, the iPads and the Galaxies that people want to bring to the workplace, and they want to sit with them in rooms and in meetings and access their emails and take notes and do work with these devices. And these are not devices that they get from or at least historically, they're not devices that most employees got from their employer. So in effect, they're rejecting the corporate devices and saying, I don't want to work with that, I want to work with this, and how about you connect me? So that's, I think, a significant part of BYOD, and it's sort of a groundswell, if you will, from new hires and sales and mobile folks and the younger folks, often the ones who are more tech savvy, if you will. But I think part of it is also coming in sort of top down. And this I often fondly call the CEO who got an iPad for Christmas, because again, as companies' senior leadership start getting iPads and Galaxies and iPhones and Android phones, and they start seeing the value of these devices, they themselves want to connect their devices to the company network. And, you know, the distance from there is a short one where the CEO will sit in a staff meeting, all of his or her direct reports see that device and say, oh, I'd also like to connect mine to the network. And then next thing you know, you've got all these senior people walking around with devices, going to meetings, and then their direct reports want to connect. And so some of this is coming top down, some of it is coming bottom down, bottoms up or top down. But regardless, it's coming in to companies, and it's coming in fast, and it's almost unstoppable. In fact, I often meet people who say, oh, our company doesn't allow BYOD, but I often question how much of that is realistic. And part of what's happening is increasingly employees are getting around situations where companies are not allowing BYOD by, for example, setting up an auto forward. So they'll have all of their emails from work auto-forwarded to webmail like Gmail or Yahoo or Hotmail, which they can then read on their personal device. So the technology today is so sophisticated, and there's just so many loopholes and ways to get around the restrictions that companies might impose that, again, even if you think that you're not allowing BYOD, you may find that folks are doing something that resembles BYOD behind your back. So BYOD is definitely something that's coming in, and it's not going to go away, and it's really incumbent on companies to figure out how to deal with that. And in dealing with BYOD, there really are two very different types of solutions. One of them are technology-oriented solutions, and the other are legal-oriented solutions. And they're not one instead of the other. They really need to both exist for you to have a successful BYOD implementation. So let's start with the legal side. So the legal side means that there has to be a policy, and most companies or all companies should have some form of we'll call it acceptable use policy. I think that's the most common name for these policies. And probably your existing acceptable use policy says that you can only use company equipment for company data. So the starting point really should be to look at your acceptable use policy, and if you are going to allow BYOD, you would need to amend your acceptable use policy to define in what circumstances you might allow employees to bring personal devices to work in order to put company data on personal devices. And by the way, BYOD, although articulated primarily as a mobile device type of thing, and most common implementations have to do with iPhones and iPads and again, Android phones and Galaxy tablets, there's nothing to prevent BYOD from also including laptops, and there are companies, although far fewer than the ones that have to do that allow BYOD in the mobile space, that are allowing employees to bring their home laptop and using that for work purposes. And so I'm going to focus my comments and my thoughts on the mobile space and not the laptop space. The laptop space raises far more complicated questions, including software licensing type of questions and questions around corporate security that go beyond anything that I can cover in this presentation. And again, I find that very, very few companies have really even tried to implement BYOD in a laptop environment. So again, when I talk about BYOD, I'm limiting it to the mobile front, but to be clear, that there's nothing that would preclude BYOD from encompassing more than just mobile phones and tablet computers. So as I said, the starting point should be your acceptable use policy, and then the next step should probably be to think about a agreement to be signed with the end user. And the reason you need an agreement is because there's going to be a lot of issues that come up in connection with a BYOD implementation that are probably not covered in your acceptable use policy and things that you had never thought about. And these are important and challenging type of questions, starting with questions around fees and costs. So when you hand an employee a BlackBerry and it's on a company plan, the company typically pays for the device, pays for the plan, and there's no real issues there. When it's my personal device and I'm now using it also for work, I may start incurring charges that exceed my data plan or exceed my minutes. Or when I travel to Europe and I go roaming somewhere and I get hit with, the €5 a minute roaming charges and come back to the U.S. with a, €1,000 phone bill, it's on my personal phone bill and I'm going to look to expense it. And so the employers may suddenly find themselves in the new world that they didn't want to be in, which is that they have to start looking at individual monthly statements for their mobile device and to start go line by line and say, this you spoke with your wife or husband and that's not me, and this you called work and this was something else and this was something else, and to start going line by line and figuring out what's a legitimate expense and how to reimburse employees for these charges. And that's something that I think many companies are not necessarily going to be quick to want to do. Another example, when you get issued a company BlackBerry, and the same when you get issued a company laptop, if something happens to that device, if it gets lost, stolen, broken, I think most companies, at least initially, will just give you a replacement device. I mean, when you lose your third laptop in a row, somebody may, and hopefully somebody will at some point say, hey, you no longer qualify to have a laptop. We're going to give you a desktop, or you're going to buy the next laptop to teach you a lesson. But at least initially, most companies will probably just say, you're getting a new device. And when it's a personal device, what do you do then? What do you do when folks are traveling and somebody stole their iPad out of their bag and they say, well, it was part of BYOD program. I was using it for work. I was traveling on business. Buy me a new iPad. Our company is going to be willing to step into that and buy a new iPad. What do you do when you're sitting in a conference room and somebody spills their coffee on your brand new iPad and the device fries and it's gone? Does the company buy you a new one? Do you ask your coworker? What if the coworker just smiles at you and says, sorry? Do you sue them? I mean, these are all things that you really have to think about in terms of what's going into the end user agreement. And then, of course, we get into the more detailed questions around privacy, my right to restrict things that you can do with your personal device. I've seen companies that restrict you from letting other family members access your device because now you've got company data on the device. So you can't have your kids playing Angry Birds on your iPad if your company email and business documents are on the same device. Is that practical? Is that reasonable? Can you really enforce it? So you've got those questions. What if there's a litigation? And now suddenly I got to interfere with your ownership of your device. I might have to take your device from you and image it or keep it in a litigation room. I might have to put software on your device to investigate your usage of the device. What if there's an internal investigation about you? And again, I need to monitor your communications. What rights do I have in terms of the laws? Can I just remotely access your device and plant some keystroke logger on your iPad like I might otherwise do, certainly in the U.S. Where companies have far more free reign than they do outside the U.S. in terms of investigations inside the company. So again, there's a lot of questions here that really become a lot more complicated from the fact that you don't own the device and you also don't own the plan. So again, you can't just go to Verizon or AT&T and say, we're investigating Ori and we need all the text messages that he sent in the last 30 days. They're going to say, sorry, it's his account. Who are you? And that's what I would expect them to say. So you're now in a situation where you might have the SEC knocking on your door and saying, we're investigating something and we need all communications. And you'll say, well, I can't really give you a lot of stuff because it's all sitting on personal devices that I have no rights to. And so the BYOD world is going to add a lot of really, really fascinating and complicated privacy and other legal type of questions that companies really need to grapple with. And you really need to try and figure out as many of those questions as you can in advance and put all of those things in an end-user agreement to set expectations. And, you should be very clear with employees that this, especially if the BYOD program is a voluntary program, and again, I suspect that there are companies that either have already gone down the path or may eventually go down the path of making it mandatory. That's a different world entirely, and I'm not going to focus on that. So I'm only focusing on a world where this is voluntary and an employee asks for BYOD and you say, okay. And then you can say, but you have to sign this agreement, and here's all the things that say I have the right to read your emails and I can access your text messages and I can do all these things, and I have to sign it and accept it. Now, is it going to be enforceable in every court, in every jurisdiction? Those are tough questions, but you can at least do some homework in advance, figure out what things you might be able to succeed with, and make sure that you've got a reasonable end-user agreement. And when I say reasonable end-user agreement is because, again, as I said, some of these questions can quickly lead down a path of being unreasonable, such as saying that you can't have family members access the device, which, again, I really doubt is going to be popular or enforceable. I've seen companies that restrict which applications you can download onto the device. Obviously, they're worried about malware and other software stealing the company data on the device. And again, it's my device, and part of owning a device is going to the App Store and downloading stuff. And it's really going to be very, very hard to restrict what employees can download onto their personal device. And so I think companies should be smart about that. Another piece that I've seen some really bizarre practices has to do with technical support, which again is something that companies need to think about. If you're a BlackBerry shop, you probably don't have the in-house expertise to support an iPhone or an Android phone. So if I'm an employee and I've got an Android or an iPhone and something happens to it, I'm going to go to the Genius Bar or to wherever I would go to support an Android phone, And the employer, rightfully so, doesn't want the corporate data going and sitting there in a place that is uncontrolled. So I've seen companies that, I've actually heard of one company that actually tells their users that if they come with a problem with their phone, then they will confiscate the phone because they don't have the ability to service the phone in-house, and they refuse to let the user go with the phone to a third party because that exposes their data, so they just take the phone. And how likely is it that employees are going to come and report a technical issue to you if they know that the end result is that they're going to lose their phone and they're going to have to buy a new phone? I think that's just crazy. So you have to be practical. Either you figure out how to provide that support in-house, or you figure out how to remove your data from the phone before it goes to get serviced outside of your company. But these are all things that need to be thought about. And that brings me to the technical side of BYOD. And by technical side, I mean finding a way to segregate your data, the company data on the device, from the user data. And this is a space that's maturing. There's some vendors out there, but there's more that are coming into this space, and the solutions are becoming better. I think as time goes by, more players are coming in with more mature solutions. And one of the concepts that I'm hearing more about now is something called dual persona or a dual log-on, which allows you to log on either as a user or as an employee, and in effect, each login, you see different apps, different data, different everything, and that I think is probably a better way of dealing with these things. Other solutions have to do with an encrypted container where the company data sits inside a container which can be password protected. And the advantage of that is, first of all, there's physical, or rather logical separation on the device, that the company data sits fully separated from the personal data, and you can remote wipe that container. Or again, if there's a password on that container, then again, if you take your phone to the Genius Bar, then you don't have to worry about somebody accessing that data. And again, if you are worried, you could just remote wipe that container, and then you could reinstall the container at a subsequent point. So it's very important to think about those kinds of questions and figure out what's going to be the right solution in your environment. But it would be a mistake to just rely on an end-user agreement and expect folks to sign something and then just walk away with their phone. By the way, there's been some interesting guidance coming out from regulators about BYOD, most recently by the UK Information Commissioner, who's issued a whole report on BYOD with some very good advice on what companies can and should do to protect personal data on the device, make sure that there's the right security on the device, and so forth. So it's worth, those of you who are going down this path and have not yet figured out how to do it, it's worth reading that document. And in financial services, there's also some guidance on BYOD coming out of FINRA. And a few other points to highlight. So training obviously is very important. Explaining to employees all of the rules of the road, what the expectations are, that's going to be very important. By the way, you may want to ask yourself if this is something that you want to offer to all employees or only to a subset of employees. I've seen places where it's only offered to executives or senior people. Other folks only offer it to mobile and sales kind of roles where perhaps it makes more sense. And if someone's just sitting in the office all day, do we really need them to be part of a BYOD solution? Ask yourself whether you want to offer this to hourly workers or folks who are eligible for overtime. That could be a huge labor and employment pitfall for you when they start coming in with overtime demands, and it's going to be very difficult for you to figure out how to manage that. And so that's something to think about. And certainly if you have folks who are in sensitive roles where, again, you worry that if they lose their phone, that somebody can use the phone to access the keys to the kingdom, then again, that person maybe it's not the smartest thing to let them connect their personal device to your network, which might be far less secure. And last but not least is the global space. Everything that I've said is U.S.-centric, and once you cross the border in any direction, including Canada and Mexico, both of whom have privacy laws, and especially as you cross the pond into Europe or cross the Pacific Ocean into Asia, you're going to start bumping up against a significant number of jurisdictions with far stricter privacy rules. In Europe, you're going to find works councils, which are sort of like labor unions, and you really have to start thinking about every single piece that I've mentioned and to see if that's going to work in other jurisdictions where you may find that you just don't have the leeway to confiscate a device or investigate a device or audit a device or do any of the things that you might think that you need to do in the United States. And if you can't do those things, then you might decide not to do BYOD in those jurisdictions, because otherwise you're doing BYOD in a way that doesn't provide you the protections that you think you need, and that would be, in my mind, highly risky. But then you've got the sort of internal political issue of what do you tell your employees? Folks in the U.S. get to do this, folks in the U.K. don't. That may not be popular. So you really need to think about how all of that is going to play out. Again, as I mentioned earlier, just remember that you're going to have to deal with potential litigation and investigation and e-discovery issues and regulators who expect you to have control of your data or access to devices with your data. And you really have to think about how all of this is going to play out in a context where the FTC comes in and to investigate something, and you just stare at them and say, I can't give you any of that because it's all sitting on devices that I can't really pull that data from.
Please pardon this interruption. I'd like to take a moment and announce the second CLE code for today's webinar. Attendees, please note the second CLE code for today's webinar is 4913. Again, the second CLE code for today's webinar is 4913. Thank you, Ori.
Thank you. The only other point that I would say is, again, make sure that you don't forget the data loss procedures that you probably have in place today for company devices, and make sure that employees know to report the loss of their personal device if it's part of BYOD, so that, again, you can invoke your procedures, whether it's remote wiping of the device. And again, if you've used one of those encrypted containers or some other solution that you can easily access it remotely and remotely wipe that part without wiping the employee's data, that would certainly be a good thing. And you want to make sure that from a reporting perspective, again, if you have, there's 46 states today with data breach notification laws, plus the District of Columbia, plus Puerto Rico, plus a bunch of other states outside the U.S. So you really need to make sure that these devices are part of your calculation in terms of your notifications and keeping track of your incidents. And that's it in a nutshell on BYOD. I want to make sure that we leave enough time for questions. So let me stop here and open it up for questions.
Thanks, Ori. I had to just that was great. That was really helpful. I had a couple of points on the BYOD point. Ori talked about this concept of dual login or segregation, and there are a lot of companies that are going towards that as a scenario, so you can actually silo your personal information, your personal contacts, for example, your personal scenarios, along with your company info. So you're two separate silos of data. It's as if you're carrying two devices like you did back in the day, but instead that you have it segregated. If you don't have that, Ori was talking about what happens if something is wrong, if they lose it. One of the scenarios is, of course, that if you lose your device, then the device has to get wiped. And so if you're carrying your cell phone that has all your pictures of your children since they were babies on it, what has been happening in practice is a lot of individuals have been a lot less likely to report a lost device than they were when it was the company's device, because they don't want their device, if they find it in 2 days in their house, they don't want to have had the device remove all of the personal information on there. So if your company is not yet enforcing this dual login segregation concept, that's another exposure that I think is implicit in what Ori was saying, but it's worthwhile to note and to explain to people through the acceptable use policy. The only two other points I would add on BYOD is that, the thing that I've heard is that that companies spend, if they've moved to a BYOD, they've spent 12% of their budget on the devices themselves, whether they're reimbursing people or having some sort of buyback process. But they spend as much, if not more, on their IT system, in part because they have to deal with the infrastructure and, for example, the cybersecurity risks of having these multiple devices penetrating on multiple levels and multiple operating systems, such that they have to have different ways of communicating, availing themselves to them, or even having different levels of sensitivity in terms of the access or the structure. And so I think those are all important things to think about for the process. And so I think it is worthwhile to think about that where we have the BYOD scenarios. One of the questions is, if you have two different sign-ins, is the thought that the company could segregate their data and keep it separate from an employee's separate data? There are, as I said, companies that are providing that capability of having a silo functionality, but I don't know, Ori, if you want to speak about that anymore.
No, again, it's exactly as you've described. You really, and it's like a dual boot computer. You go in or a multiple account computer. So you go in and you see several icons, and depending on the icon that you click, that's the profile that you go into, and you can set up the profile with different applications. You of course have to replicate data. So if you have contacts, and if you want to have the same contact, you would have to copy it because part of the intent behind these sort of dual persona solutions are that you can't move data from one to the other. There's no way to do a cut and paste or copy because, again, the point is to keep that information secure. So if you have hundreds of contacts and you say, well, I need those contacts for work and I also need those contacts for myself, you will find that you're going to have to figure out which contact goes where and create two separate contacts. And that, of course, can be a little bit of a pain. And, of course, those people who might want to consolidate their calendar and think that it's really helpful to have a calendar with their work meetings and their school and children and everything else all in one place, then again, this kind of will defeat that purpose unless you maintain two replicas of that calendar. But if you do that, putting the corporate meetings on your personal calendar is going to probably violate the company requirement that you keep the data, the company data, in the, we'll call it, corporate partition. And so while you would be welcome to put your individual meetings on the corporate calendar, probably, you wouldn't be allowed to put the corporate meetings on the other calendar. So that means that so these solutions, they sound great, but when you start living with one of them, you start realizing that there's always some twists and some complications. And by the way, another one of the potential complications when you roll out new software onto a device, sometimes the software doesn't work as advertised and might even cause a device to crash and might cause you to lose all data. And that's another thing that's good to cover in the user agreement that you sign with your employees, is to remind them that basically as part of them agreeing to BYOD, they agree that you can put software on their device, and if the software by chance erases all their data or breaks the device or does something else to their device, it's a risk that they're assuming. And again, that's not necessarily something you can get away with in all jurisdictions. So you have to think about that. But as a practical matter, I think if you've got a good IT shop and they test these applications in a development environment before they roll them out, then it really would be a rare event that something like that would happen to your device. I did see a question. Someone asked what was the document I mentioned earlier. It's the Information Commissioner's Office, or ICO as they're called in the UK, and they've issued a document in the last month or 2 months called Bring Your Own Device, or BYOD. And I'm pretty sure that if you type ICO BYOD into Google, you should be able to find that report.
And that's a great report. I think it's by far the most comprehensive report and suggestions, recommendations on BYOD that I've seen. And I think it maps, as Ori said, pretty closely to what you would want to do in the States. It mentions those work councils issues, but beyond that, I think the recommendations are very practical.
Yes. And, one other thing to think about, and again, I think it's one of those things that's really difficult to solve, but we all know about the phenomena of people texting and driving. And again, you have to realize that as you allow folks to join a BYOD program, that puts somewhat of a corporate nexus to the personal device. And if you do have an accident by an employee who's been texting and driving or doing anything else on their phone, checking emails, calendar, or what have you, that could create some exposure to the company, especially if it can be shown that they were doing something work-related on their device, but probably even if not. And so that's another area where I think probably some training and stark reminders to employees to be careful with that would be very useful. And again, I always tell folks BYOD is like an onion. The more you start living with BYOD and the more you start trying to implement a BYOD program, the more you discover more new layers, new nuances, new questions that emerge, new concerns that emerge. I've spoken about this, and I mentioned once the point about Siri, and then somebody walked up to me afterward and said, we implemented BYOD in our company a year ago, and this is the first time that somebody mentioned that, and I'm so glad you said that. But you have to remember, when you talk to Siri, that data goes to Apple, and actually Apple recently disclosed that they keep the data for 2 years. So if you've got somebody who's working with their personal iPhone and they're talking to Siri and they're sharing confidential information, that information is going out of your control. If you're an attorney, maybe that was just a violation of your attorney-client privilege obligation. I think it'd be fascinating to see the first lawsuit where somebody argues that something is not privileged because it was shared intentionally with Siri, which means with Apple outside of the privilege. So there's just endless layers, and as I said, this all ties to the concept of the mobile applications, because again, as you start loading mobile apps on your phone, if one of those apps takes access to your contacts, when it's my personal iPhone and my contacts, you don't really care. When it's my work phone and it's all of my work contacts, and if I'm a salesperson, suddenly sent all of my sales contacts to some app developer somewhere. So there's a lot of potential pitfalls here. And that's why I said at the very beginning, I don't know that any company has sat and had a strategic decision of let's do BYOD, because I think that if people really spent enough time thinking about all the potential ramifications and risks that they're exposing themselves to, they probably would have decided not to walk down this path. But again, in my mind, this genie is out of the box, and I find it increasingly difficult today to have a conversation about let's not allow any BYOD in the workplace. I think that that's going to be very, very difficult to do. I wouldn't be surprised if over time, as more of the pitfalls and risks come to bear, and as regulators, for example, financial regulators or healthcare regulators, start to weigh in this space, perhaps imposing far stricter obligations on companies, that it might change the dynamics. But at this point, it seems that it's one of those spaces that you really have to figure out a little bit on your own.
To repeat the information that's requested about the guide on BYOD, it's from the Information Commissioner's Office of the United Kingdom, and their URL is ico.org.uk. And as I said, the Information Commissioner's Office has this BYOD, or Bring Your Own Device guidance, as a PDF. That is a very useful document. Hopefully you guys all got that. I know we're getting close to the end of our time. There is a question about the CalAPA that we talked about before, and it says, for CalAPA to display a privacy policy before app download, would it have to be linked from or displayed in the App Store or Google Play Store? What is the scenario? CalAPA, the statute requires that it can be conspicuously posted, that the privacy policy be conspicuously posted. The California Attorney General has taken the position that conspicuously post means to display it in the App Store itself prior to download. So yes, it would have to be linked from or displayed in the App Store for the Google Play download page. And the platform providers had that statement of joint principles with the California Attorney General, and therefore the privacy policy, there's now been a kind of a set place to have a privacy policy be available. You can't do an accept or a click-through, but it's physically available. But the Attorney General has also taken the position that conspicuously post means before download and available on every page. Now, in privacy policies on websites, they're often in the footers, and that's kind of the default, and that's been considered to be conspicuously post. But, there's not a lot of real estate on the devices. A lot of people have put them in their settings so that if you click on the little settings icon, you can get to it there off of every page, but not actually have the link available. But again, with the Delta litigation and any potential litigation, that may be further resolved. There is no attempt to modify CalAPA with regard to this element, the conspicuous safe host element right now. Therefore, we'll have to wait for the guidance, but the Attorney General's position has been clear before download and available on every page. With that said, Kathleen, I think we are running out of our time.
Thank you both. And on behalf of LexisNexis, I'd like to thank both Mary Ellen and Ori for an outstanding program today. To our audience, thank you for attending today's complimentary CLE webinar. We ask that you please follow the link to our survey. Your feedback on products and services is an excellent resource for us. Thank you all and have a great day.